I think I answered your question.
I don't think you did, so I'll ask it one more time.
All right, no comments, please.
Do you think that providing a direct examination to the defense before you testify is in any way assisting preparing for your testimony?
Again, I don't know if he even utilized it, sir. And certainly if the Commonwealth had reached out, they could have gotten a copy of that as well. It would have been the same exact outline, whether I testified on behalf of the defense or behalf of the Commonwealth.
You don't want to answer my question. Did you ever make any comments or discuss the outline that you provided to the defense to help better the testimony for the defense?
I did put comments, yes.
When I just showed you that document, you said you just sent it because this is a standard thing. Why didn't you just tell us that you made comments that would assist the defense? Why didn't you share that when I just asked the question?
Hey, Roberta, Sandy, Wendy, good to see you. Krista, Melinda.
My question, I asked you about the outline, the direct examination you provided to the defense, and you gave me a response that this is something typical, but it's just an outline. You wouldn't answer whether it would help the defense or not, but the reality is you weren't assisting the defense, isn't it?
I'm going to allow that.
You were.
Of course she is.
To help the defense, weren't you?
Sir, it wasn't to help the defense. It wasn't to help anyone but the jury understand things. As I just mentioned, that outline, if it was asked if I had sent one to the Commonwealth, you would have gotten the exact same copy.
You didn't send one to the Commonwealth.
Commonwealth didn't
never
ask
reached
for it.
out to us, sir.
So what you said in this is there was a question about, so not being able to inspect the vehicle is something that is not uncommon in your line of work, and you wrote back, absolutely not, correct?
Correct.
And you made a comment to assist the jury, according to you, only to assist the jury. Not sure if you want to put this somewhere in the direct examination. I have a feeling they are going to argue I didn't personally inspect the vehicles. I had enough information from the material I reviewed, so it wasn't necessary. Need to show jury it doesn't matter in this case. Were those your comments to the defense before your testimony?
Absolutely. And it would have been the same argument probably from the defense if you had called me a witness about not being able to inspect the vehicle. I wanted the jury to have an understand that for the analysis I undertook, it did not matter that I did not physically inspect the vehicle, sir.
So when you're telling us here under oath before this court that you did nothing to assist the defense, you do not think that you making these suggestions on how to better the testimony for the defense, you don't think that's helping the defense?
No.
Okay. You said, not sure if you want to put this somewhere in the direct examination. So you're making suggestions to the defense about what you think could be helpful in the direct examination, correct?
Sir,
Like
there
the
were
judge
numerous
does to the
conversations
prosecution.
between me and Mr. Jackson about what questions to ask, what not to ask. Again, I prepared that internally on my behalf and sent that to him. Whether he utilized it or not, I have no idea.
Not my question. Not my question. What I'm asking you is when you wrote to the defense and said, not sure if you want to put this somewhere in the direct examination.
Yes, slow down.
Sorry. When you wrote and offered, unsolicited according to you, to the defense, not sure if you want to put this somewhere in the direct examination, weren't you trying to help, sir?
I don't believe so, no, sir.
And then when you wrote, I have a feeling they are going to argue I didn't personally inspect the vehicles. Who's they?
Well, it would have been the prosecution in this case.
But you're not taking sides. You're totally objective, right?
Sir, that is a question that's routinely raised when I testify about whether or not we inspect the vehicle. So I know it would be a potential issue that would be raised by either side.
So you were alerting the defense that you thought that this may become an issue, weren't you?
It was more or less to make sure the jury had an understanding that because I didn't physically inspect the vehicle, it did not matter for my analysis, sir. I wanted to make sure the jury understood that.
Don't hide behind the jury. I'm talking about your communications with the defense. I'm asking you specifically about your conversations with the defense.
That's two questions. Ask one question.
You wrote, I have a feeling they are going to argue I didn't personally inspect the vehicles. That's what you wrote, correct?
Objection, Your Honor. The tone of the argumentation.
Did you write that?
Yes.
Right. And when you said they, you're referring to the opposition, the Commonwealth, correct?
Correct.
Right. And you offer an explanation or a way to deal with what the Commonwealth may confront you with, don't you? You make a suggestion to help the defense, don't you?
Again, it was to help the jury understand that because I did not physically inspect the vehicle, it did not matter for my analysis. That was the point I was trying to make.
I had
finish.
enough information from the material I reviewed, so it wasn't necessary. Need to show the jury, it doesn't matter in this case. That's what you wrote.
Right. Need to show the jury. That's what I was trying to make sure that that point was understood to the jury.
In your collaboration with the defense, that's not all you wrote, is it? You gave them discretion about things that you should or shouldn't say in front of that jury who you say you want to hear everything. Didn't you?
There were other comments. Yes.
If you want the jury to hear everything, you wouldn't be relying on the defense to tell you what to say and not say, would you?
I don't know if I understand your question.
Okay, you'll understand if I read this. Number 19. Would it be fair to say that because you do a lot of nighttime visibility work, your cases frequently involve pedestrians? You remember that one?
Yes.
And then you wrote back, yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. You remember that?
Yes.
Statistically speaking, most pedestrian fatalities occur during the evening and night hours. You remember that?
Yes, sir.
So my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. Yes?
Yes.
And then do you defer to the defense, not the jury, trying to give the full story to the jury? Do you defer to the defense in exercising discretion on what you will or will not say to the jury back then?
Well, allow me to explain, if you will.
I'm asking you a question.
Let me explain.
No, I'm asking
So
you, did you defer?
Answer the question first.
Did you defer to the defense on what information they wanted you to put in front of that last jury or not?
I didn't defer to them. The reason for that comment is a few reasons, sir.
Let me read it and then you can give any explanation you want.
Hold on. Question, Mr. Brennan.
You
and
said-
then you answer, Dr. Wolf.
You said, if you don't want me to say this, that's fine. Are those your words?
Yes. Allow me to explain. Because for one, I want the jury to have an understanding, again, the jury to have an understanding of my background in lighting.
You know what's better than waking up to a bunch of unread emails? Waking up to extra money in your account. That's exactly what I and thousands of my members do every single morning. We trade in the stock market live in real time with no delay. Now, before you ask, no, I don't sit in front of the charts all day long. I only trade for 1 hour a day before work, and that's all it takes. Most people think trading is complicated. It's not if you follow a system. I trade the same setup every single day, and my members follow along. So if you want to make money before work, without quitting your job, I put together a free training video that shows you exactly how it's done. So click the link below, and I promise you, it's way more important than the video you're about to watch now.
Let's face it, car buying hasn't been easy lately. The market has been crazy with price fluctuations, high interest rates, and inventory shortages, and now tariffs. Hey, Scott Lehman here from Premier Auto Center, and I'm your car buying coach. As a dealer for the people, I've made it my mission to help you.
No, I did not inform the court.
You relied on the defense and gave them the discretion whether they were going to clarify the record or not. Correct?
But I provided the clarification, yes.
Mr. Brennan, could you move along, please?
As you sit here today, you don't really know how many communications you had with the defense before your last testimony, do you?
For trial one,
Yes, trial one.
I think it's all memorialized in the records and the emails that were produced.
The ones that were produced, but not things that were lost or destroyed or deleted, correct?
Again, there are records, even though the physical texts aren't there, there's certainly records of the calls incoming, outgoing, as well as texts.
Do you remember when you testified in the voir dire, you were asked that before that morning when you walked into court, you had never met Attorney Jackson face to face?
Correct.
But you met him in court that day, right?
I believe I met him that day, yes.
You were asked whether or not you had ever discussed at trial now, after the voir dire, on June 24th, you were asked whether you ever discussed the substance of any of your testimony. Do you remember that?
Correct.
And so when
Do
you
this.
shared questions and answers and suggestions by email, was the statement under oath, you and I have never discussed the substance of your testimony. Is that still truthful?
We never discussed it, sir. Again, I sent it to him on my own behalf. There was
And-
no discussion that took place between Mr. Jackson about that.
You made comments after this was exchanged.
That was sent with the comments, sir.
And then you were asked whether you had ever been paid by the defense. You said no. You were later paid by the defense, weren't you?
ARCA did send an invoice afterwards, yes.
Did you talk to ARCA about that? About the billing in this case?
No.
You submitted your bill? Yes?
ARCA submitted the bill?
Yes.
Yes.
Mr. Klein, he was involved in the testing you did, wasn't he?
Yes.
Why is it that Mr. Klein didn't come in and join you? Who made that decision for trial?
Well, I think it was around, again, when we were talking
Lisa
about those
Smokes,
June
good to see you.
calls, I think that there was some discussion between Mr. Jackson and myself about Mr. Klein's involvement. And ultimately, he's also an accident reconstructionist. So it essentially would have been duplicative testimony. So we didn't feel, or Mr. Jackson, I don't think felt it was necessary to call Mr. Klein as well.
That sounds like a little bit more than just scheduling, doesn't it?
I would describe that as logistics, sir.
Logistics. You had to describe what Mr. Klein's role was or wasn't in that report, didn't you?
Again, I went over his background as an accident reconstructionist, yes.
Well, so you only talked about background, and from that, the decision was made not to call him? Or did you talk about his role in your testing and in your opinions?
I didn't talk about his role, sir. I think ultimately the decision obviously was made by Mr. Jackson, not
I
me.
understand that, but I want to know what the conversation was that led to the decision not to call Mr. Klein. It wasn't simply logistics. What was the discussion you had?
Well, I told him that, again, we're both accident reconstructionists. Dr. Wrenchler is a biomechanical engineer, so there would have been essentially duplicative testimony from both of us.
Well, your report's never very clear who did what. Would you agree with me if the report is a general report that has yours, Dr. Wrenchler, and Dr. Klein's name on it? Would you agree with me?
All three of our names are on it,
It
yes.
doesn't distinguish who did what in that report, does it?
Correct, but I think it certainly was testified to at the voir dire in the time of trial.
Before the voir dire.
Yours.
When you spoke to the defense, did you explain to them what the different roles were for the different people that led to the decision not to call Mr. Klein?
Again, we went over our backgrounds, and I think from that you can deduce that.
I don't know what that means.
Well, if you're familiar with what an accident reconstructionist does and you're familiar with what a biomechanical engineer does, then you would be able to understand that.
Well, it would be easier to understand if you could just tell us what the conversation was. That's what I'm asking about.
I'll allow it.
When you had a conversation with the defense, did you tell them the
Score
role
one for
Mr.
Bev.
Klein played in your investigation and in your conclusions?
Again, I told him that we are both accident reconstructionists.
Okay. And he chose you instead of Mr. Klein. Did you say there was a difference between you and Mr. Klein and what you did?
No, again, we were both a part of the testing. We were both a part of the review. So we had exactly the same role, essentially.
Did you tell him that?
No, I told him that we were both accident reconstructionists.
And you remember that's all you said about it?
Yes.
During the voir dire and the trial, did you get to watch any of the Commonwealth's experts?
No, I don't believe so.
Did you ever communicate with the defense about any questions and answers that could or should be asked?
No, but I will note that during the entirety of the first trial, the Department of Justice was closely watching it, and we had certainly a direct line of communication with them that was giving us, providing us information about the trial as it was ongoing.
Because you were being investigated by the FBI.
Answers to ask.
No, sir.
Did you ever see anybody's testimony at any time during the first trial?
I might have seen a few news clips, but I didn't watch any specifically, no.
Did you ever watch anybody's testimony? Did you ever watch any of the reconstruction's testimony?
No, sir.
Did you, after the trial, spend any private time with the defense?
No, I left town.
Okay. You didn't go to lunches or parties or anything like that?
No, I went straight to the airport.
And sir, is there any other communications that you've had with the defense that you didn't tell us about outside the texts and the phone calls and the signal calls, or any other communications that you can think of that you had with the defense?
No, sir. I've provided everything I have in my possession.
I have no further questions.
You know what? The one of the reasons that this whole process is going on is that cat right there was actually hired by the Federal Bureau of Investigation, right? And he was working, or his company, which I believe called ARCA or whatever, was working for the FBI, investigating Troopa Procta and everybody else in there. So what they're trying to do is they don't want, after after he was done investigating the entire accident for the feds, they hired him. The defense said, "Great, we're gonna use them as our reconstructionist," and the prosecution's pissed.
Your Honor, may I approach the witness for the document?
Yes.
Thank you. Dr. Wolf, I am providing you with a document. Do you recognize it?
Yes.
What is it?
It is the order for production of records.
And is that an order from this court?
Yes, sir.
And is this the order that you were provided with in response to recent matters with regard to this court and what you should or should not be keeping in terms of records and what you should be producing with regard to records?
Yes.
Could you please read the, excuse me, at this time, Your Honor?
I have it in front of me.
Okay, well, I understand. So if Your Honor has it, I would like it to be part of the hearing.
Sure,
Right?
we can mark it.
Yeah, that's exactly. Thank you.
Down, 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 down. Put a 2 in there if you do not like the prosecution. That dude's smarmy.
I offered it into evidence, Your Honor.
Okay.
May I allow the witness to have that,
Yes.
please? Thank you. Take that.
He's creepy. Show and tell time. And you know something, earlier in the day when the defense was asking for Mr. Wolf to put this up or Mr. Wolf to put that up, that's him. They hired him.
With me, Your Honor.
They must hate that. Boy, they must hate that.
Dr. Wolf, I realize that the court has a copy of this, but I'd like you to please read the first sentence in the indentation at the top after following.
Okay. All records within ARCA's or its owners, partners, employees, or representatives' possession, custody, or control in whatever format kept that reflect or in any way relate to work performed or contemplated and related in any way to billing, payment, compensation, and or reimbursement of any kind in connection with Commonwealth versus Karen Reed.
Did you, and to the best of your knowledge, everyone associated with ARCA comply completely with this order with regard to the records that are requested in it?
Yes, everything I had in my possession and that ARCA had in our possession, we produced.
What I'd like to do is to go back in time with regard to your interactions with the United States Department of Justice in February of 2024. Was ARCA under a contract with the United States Department of Justice?
Yes, sir.
Was there a contract number assigned to that contract?
Yes.
Was there an internal number at ARCA for which all time was billed for your work on that matter in February of 2024?
Yes.
Did that contract number that began in February of 2024 ever change in ARCA?
Well, let me just clarify something real quick. So the original case when it came in from the Department of Justice was in the year of 2023. So when that project was opened with the Department of Justice, we assigned a project number to it. That project number from the original case with the Department of Justice remained the same all the way through the trial.
And now let's go from in the trial in June of 2024, correct?
Correct, yes.
From June of 2024 to the end of December of 2024, did that contract number ever change?
No,
To your knowledge, when you were entering time under that contract number for your work, did you understand that that time was going to be billed to that contract number with the US government?
that was my assumption, yes.
Did you have from any time in 2024 any understanding that any of your time that you were entering was to be billed to the defense team in this case?
No, sir.
Let's now go to your first interactions with the defense. As I understand it, well, why don't you tell me what was the first date of your understanding of interactions with the defense?
I believe it was sometime in mid to end of March of 2024. Again, that would have been over a month from when we issued our report to the Department of Justice.
Your Honor, may I approach the witness?
Yes.
Thank you.
You notice how the defense questions are a lot more concise? The prosecution really looked like they were fishing.
What I have is the entire production that ARCA made. I think it would ease in terms of the,
Sure, he can have it.
thank you. Use that pursuant to the subject of the Honor's permission to answer any of my questions if you need to.
Okay.
Now,
follow what I'm saying,
in
though?
March of 2024, had your final report been issued, the final report that you prepared for the U.S. government?
Yes, that was issued on February 12th of 2024.
From February 12th of 2024 until you sit here today, has there been any change whatsoever to that report?
No,
Have the conclusions in that report stayed the same since it was finalized for the U.S. Department of Justice in February of 2024?
yes, and that was testified to at the voir dire and certainly at the time of trial.
Did the defense at any time have any discussions with you about the substance of that report to the United States Department of Justice?
No, we had no idea who the defense was or the Commonwealth for that matter.
And when you took the stand in the voir dire testimony in the first trial, before you took the stand, did you have any discussions with any member of the defense about the substance of that report?
No, sir.
Did you have any discussions with any member of the defense before the voir dire testimony other than discussions about background and qualifications?
Other than, again, some logistics about how to get up here, where to go, things of that nature. But beyond that, no.
Other than logistics, how to get up here, when you were coming, background qualifications, did you have any discussions with any member of the defense of any kind with regard to the report to the U.S. Department of Justice?
No, sir.
Did the defense ever try to get you to improve or change any aspect of the report you had issued to the Department of Justice?
No.
At the time that ARCA was working for the United States Department of Justice, do you know whether ARCA could have been retained by any other party for any aspect related to the February 2024 report?
I'm not sure I understand your question.
That was confusing.
In 2024, did the federal government prevent ARCA from entering into any contract with any other party with regard to your report of February of 2024?
So we were, again, because we were still under contract with the Department of Justice, we could not have any other formal agreements, contracts, retainers, anything of that nature, because we were still under contract with the Department of Justice.
Now let's go to the emails that were discussed with you, starting with March 20, 2024, and then the subsequent email of March 22nd, 2024.
The defense has the advantage of actually knowing how much they interacted, right? The prosecution is actually fishing. It's a whole lot more difficult for them. And it's the reason that they ask questions like, you didn't have lunch with them? You guys didn't go to the airport together?
Okay.
Because they honestly have no
I
idea.
think so.
Okay, well, let's test to make sure. March 20, 2024, 10:49 a.m. from Alan Jackson to Daniel Wolf. Do you have that?
Yes.
And that email states in substance, thank you so much for taking the time to get on with the phone this morning. Pursuant to our conversation, please feel free to forward an engagement letter to this email address. I will get that countersigned and returned to you forthwith along with your retainer as required. As of March 20th, 2024, was there any understanding that ARCA would be compensated by the defense for any aspect of current or future work?
No.
Was there any understanding or discussion that ARCA would receive any reward or payment or compensation for any contemplated work with the defense?
No.
The discussions that you had with Mr. Jackson that are the subject of this March 2024 email, were there any inducements to ARCA from the defense?
No, sir.
After that email was received by you, did you have any understanding or expectation of any kind that ARCA would be compensated for any work associated with this case?
No, sir.
What was briefly the essence of that conversation that's discussed in the March 20, 2024 email?
Well, if it correlates to when I'm looking back at this phone record log, there was an incoming call to the ARCA main line on March 20th, 2024 at 7 a.m. And that's Pacific Standard Time. So that would have been at 10 a.m. Eastern Time. So that call lasted for 39 minutes. And as I mentioned earlier with Mr. Brennan, I think that was a conversation about Alan trying to get in touch with me, letting us know that, hey, we've received your all's report as part of this federal investigation. You know, how can we go about utilizing you guys to come testify at trial? Can you guys come testify at trial? So, and then as I mentioned, I went over him with our typical, protocol for when a case comes in and a client wants to utilize us to testify, which is certainly outlined in that email. But obviously, given the very unique nature of this case, I had no idea if that was something that was okay, if it was allowed, what to do. So subsequent to that email, I then reached out to the Department of Justice to get clarification on what the guidelines would be to move forward.
I'm going to come back to these emails, but I want to go right to the July invoice from ARCA to Worksman Jackson Firm. So can you locate that? Is that in your production? It's the July invoice.
Yes. I have it located, yes.
Did you ever have any discussion of any kind with any member of the defense
Correct.
team
The jury
about
is not
that
watching any of
invoice
this.
before July 12th of 2024?
No, sir. And I will note, I am not a part of the invoicing or accounting at ARCA. When a bill goes out, how much it goes out for, who it goes to, I'm not a part of that at all.
For each and every entry on that invoice, did you have any understanding that the defense team, as you're making each of those entries, any understanding that the defense team was going to be paying for any of that work?
No, again, I think my boss wants to know what I'm doing with my time, right? What am I working on? Am I sitting there twiddling my thumbs, or am I working on a case? So that's the purpose of tracking time, sir.
So can you please describe how it is you enter time and what it is, what your thought process is as you're entering each of those time entries? Not each one, but just collectively. How do you do it? Why do you do it? And how does that work in your firm?
So again, there's usually just a spreadsheet. Sometimes I'll write it down. Maybe my project manager will enter it. But ultimately, I keep track. If I've got, an 8-9 hour day, right? I'm working on multiple cases that day, right? So I figure out, all right, did I have a telephone call? Did I work on a report for this long, right? So I keep track of my time in a spreadsheet so that ultimately, again, my boss and the accounting department knows what was Dr. Wolf doing on this day, this month.
Let's take the first entry on May 1st, 2024. You see that?
Yes.
Did you have any understanding when you made that entry that the defense was going to be paying for that time?
No.
6/9/2024. Did you have any understanding when you made that entry that the defense was going to be paying for that time?
No.
For any entry
This is
on this invoice, did you have any understanding that the defense was going to be paying for this time?
No, sir.
When you're entering this time, if you had any understanding, was your understanding that this time was under the contract with the U.S. government?
Yes, because that's the project number that I put that time towards.
So at the time you're making each one of these entries on this entire invoice, what project number are you billing to, and which one do you have in mind at that time?
I don't recall it off the top of my head. I know it was the project number for the Department of Justice case, though.
Right. I'm sorry. I wasn't asking about the specific number,
Right.
but the ultimate client, when you're making each of these entries, who is it?
It's the Department of Justice.
Is it the defense in this case?
No, sir.
it's the DOJ.
Did you ever have any discussion at all with any member of the defense team that this invoice was going to be sent to the defense?
No.
For any entry on this invoice, did you ever have any belief that you were retained or engaged by the defense?
No, and as I mentioned earlier, again, the Department of Justice
'Cause he
forbids
wasn't.
that. So we could not be retained or in a contract with the defense.
I would like to now go back to
That stopped after their investigation. Then they could be hired.
the emails we were talking about, specifically.
So this is out of earshot of the jury, everybody.
2024. I want to now go to the March 22nd, 2024 email. I'm just going to shorthand that, refer to it as the pause email.
They're trying to determine whether or not they're going to allow this person
What
in
had
because
happened
the prosecution
between
says he's
March
dirty.
20th, 2024 and March 22nd, 2024.
Do you have the tab for that, the email? That
he
you
was
were-
working for
sorry.
the
That one.
Department of Justice investigating Trupa Procta and all the dirtiness that was going on during the Karen Reed case. But they found out so much cool
Right, so
crap and they were so good at
first email that
reconstruction,
we were
they
talking
hired him.
about on March 20th, 2024, from Mr. Jackson to myself. It looks like the next email was from me to Mr. Jackson 2 days later, March 22nd, 2024 at 6 a.m., I sent an email saying, "Hi, Alan. Subsequent to our conversation on Wednesday, the U.S. District Attorney's Office has asked that we pause on any further conversation until we receive additional information from their office regarding our involvement moving forward. I will provide you an update when I have it." So what it sounds like, and from what I recall, is that between March 20th, 2024 and March 22nd, 2024, I had reached out to the U.S. Department of Justice and the U.S. Attorney's Office to get clarification on, again, moving forward with potentially testifying in the case.
And what did the United States Department of Justice tell you?
They said to wait basically until they internally figured it out.
So what was your conclusion from that conversation as to whether you could do any work on this case at that point?
At that point, I didn't even know if we were going to be allowed to testify. I know that from my conversation with the Department of Justice, I knew that there was a great deal of confusion on their end on whether or not, as expert witnesses involved in a federal investigation, if we would be even allowed to testify in the state matter. So their legal teams were trying to, I think, figure out what the road forward looked like.
And
once they
you
were done with their
entering
investigation,
time under that U.S. contract matter in March of 2024?
Yes.
And do you know where that time was being billed to?
It would have been the same project number as the Department of Justice one.
That time was not, to your knowledge, being billed to the defense, was it?
No, again, there was through the entirety from, again, when the case from the Department
Good
of
call,
Justice
Linda.
came in 2023 till the trial concluded, all of the time was put to that one project number.
In March of 22nd of 2024, was any engagement letter sent to the defense?
No.
As of March 22nd, was there any retainer sent to the defense?
No, there was never a contract or retainer sent to the defense in 2024 at all.
So in terms of the discussion in the March 2024 email about engagement letter and retainers, were any of those ever sent?
No, we were not allowed.
And let's go back to that discussion of March 20th about engagement letter, retainer letter. Was that discussion where you were talking specifically about what you were going to do with the defense in terms of that relationship, or was it a general specific type discussion of the policies and billing procedures of ARCA?
Certainly, as is alluded to in the email, I prescribed to him our typical operating procedure for when a case comes in. But again, I remember a part of that call, there was a great deal of confusion about what do we even do from here.
So as of March 22nd, 2024, can you just briefly describe whether there was any further
Hi, Lisa, good to see you.
activity at all by ARCA with regard to the defense?
No, I don't believe so. I don't think that there was no communication, I don't think, until about a month later in April, after I had received that clarification.
Now let's go to April. Let's go to the voir dire hearing of April. When you sat on the stand under oath for the voir dire hearing, had there been any substantive conversations about the topics in the February report to the Department of Justice?
No, sir.
None at all?
None.
What briefly were the substance of the conversations you had with the defense team as of the moment you sat for the voir dire hearing in April of 2024?
Again, they were all scheduling, logistics. And when I look at these records here, I see a phone call for 3 minutes, 5 minutes, 6 minutes, 6 minutes. There's a few that are for 1 minute, which I think, again, we were maybe just playing phone tag. But again, these calls are very short in nature. So again, it was just trying to figure out, obviously I know that this was a large trial, a lengthy trial, a lot of witnesses, things are fluid. So I know that Alan ultimately, I think, would reach out to me. And then, like I said, he would give me an idea. Hey, can you come this day, right? And then I would relay that to Dr. Wrenchler and say, yeah, that works for me. So that I would get back to Alan. So that's what those conversations were. Again, coordinating our testimony to appear for the voir dire.
It might appear to some that there were a number of conversations before in communications with the defense before you sat for the voir dire hearing. Were those conversations about logistics, background and qualifications, or did those conversations entail other topics?
No, it's what we've covered. Again, that March 20th, 2024 phone call, the very first one of 39 minutes, again, was us trying to figure out what the heck to do. The May 1st phone call, which was 40 minutes, again, was me going over my background, the work that I do, my qualifications, education. Other than that, there are very short phone calls, like I said, of 6 minutes, 3 minutes, 1 minute, 9 minutes, right? And again, that was in preparation to appear in terms of scheduling, logistics, timing for the voir dire.
And they basically did the same thing at voir dire they're doing now.
Hearing. Do you recall the Commonwealth asking you any questions at all about whether you were being compensated by the defense?
I don't recall a single question by the Commonwealth on that, no.
Did the Commonwealth ask you any questions at that voir dire hearing about whether you had any substantive discussions with the defense about your February report to the United States Department of Justice?
I don't believe they asked, no.
Did the Commonwealth at that voir dire hearing ask you any questions about whether you had any promises or inducements from the defense before you sat down for that voir dire hearing?
No.
So they didn't do their job in the beginning, and now they're trying to do it now. And Bevel let them do anything.
Next tab, with regard to the outlines that you were asked on direct examination by Attorney Brennan. You've described this situation.
All right, peeps, I got to hit the bathroom. I'll be right back.
How it is you viewed this situation. Have you ever been in this situation before where you're under contract with the federal government? There's rules of the road, so to speak, as what you can do, what you can't do. And then you've got a private defense team. Have you ever been in that situation before?
No, I think it's truly one of a kind. And I don't know that that'll ever happen again.
And have you ever been in a situation like that since?
No, sir.
Did that cause you to have more or less communications with Mr. Jackson to figure out what it is you were going to do or not do?
Sure, yes.
In terms of your outlines that you sent to Mr. Jackson, did he ever broach in any way at all any idea of you sending him an outline?
He never asked, no.
Was there even any discussions that you might send an outline?
No, as I mentioned, it's something that for me is customary as I'm preparing internally for trial, right? I'm not going to come to trial, not review anything, not look over my notes, right? It's something that I do internally so that I can have an understanding how do I want to try to answer questions that might be posed to me such that I can have the jury understand how did I arrive at my opinions.
Was it important to you before you sent that email with those outlines? Was it important to you that the jury got a fair and accurate presentation of the work you had performed in association with your February report?
Yes, I think that that's my job.
Was there any other motivation that you had in sending that outline in that email to Mr. Jackson other than making sure testimony was elicited that would make your perspective clear to the jury?
No, that was the only reason.
Were you trying to in any way favor the defense, give the defense any favor with regard to that trial?
Absolutely not.
What was your goal, both with sending the outline and the testimony at trial? What was your goal?
Again, as I mentioned, I think it's to help the jury understand the report.
This,
the
folks, is the
analysis,
defense.
What I did, what I reviewed.
Did the defense
The prosecution was really condescending.
ask you to communicate to the jury about any aspect of your report in any way?
No, sir.
And did you, in fact, communicate to the jury what it is you intended to effectuate the goal that you just explicated?
I think so, yes.
And with regard to the comments that were in those outlines, what was your intention in putting in those comments?
Again, is to provide the jury, again, like for example, with the nighttime pedestrian statistic, right? It was to have them have an understanding that I wanted them to have an understanding that I do a lot of nighttime invisibility work, right? So therefore, I see a lot of pedestrian impacts. But again, I don't want them to take that statistic and say, well, we have this alleged incident. There was bad weather conditions. It was nighttime. Oh, therefore, we should give that more weight.
And is that desire of yours in your mind to help the defense more than to help the Commonwealth?
No, it's impartial. And I will note, I give numerous presentations. And I think slide 2 or 3 on presentations I give, it's going over that very same statistic. I would never shy or hide away from that statistic. And I believe I testified to that very statistic or that comment at the voir dire and in my trial testimony.
In terms of after you sent the emails with quals and
It's confusing at this point, Linda, because the jury isn't here.
leading to direct testimony, did you ever have any communication of any kind whatsoever with the defense team?
No, he didn't. Mr. Jackson didn't even respond. And I think when I sent the direct outline, it was Sunday evening before I hopped on a plane. And I think by the time I got into Boston, it was like 1 a.m. So I didn't even have a chance.
When you took the stand to testify the next day in that trial, had you had one word of a conversation with Mr. Jackson or any other member of the defense team about the substance of your upcoming testimony?
No, sir.
So you sat during that trial and gave testimony to the jury without ever having talked to a member of the defense team about the substance of your February 2024 report?
Correct.
There's no jury, so these guys are just showing off and slapping back and forth at each other.
Recall any member of the Commonwealth?
They don't have to worry about a jury thinking they're
during your
jerks.
trial testimony about whether you had been compensated by the defense?
No.
Do you recall the Commonwealth ever asking any questions at all whether you had communicated with any member of the defense with regard to your testimony while during your trial testimony?
I don't think that was asked. No.
Do you recall any questions from the Commonwealth about whether back in March or any other time you had been promised or induced by the defense? You remember any of those questions?
No.
Do you remember any questions by the Commonwealth at either the voir dire or the direct testimony about whether you had had conversations with the defense?
No.
Do you remember any questions of the Commonwealth at all before you sat down and after you sat down for trial about whether you had any text communications with any members of the defense?
No.
Linda G, you're looking good and green.
At the end
Welcome
of
to
the
Ensign.
trial, did you have any understanding whatsoever that ARCA was going to be compensated by the defense?
No.
At the end of the trial, did any member of the defense ever say to you, we're now going to compensate you for any of your work up to the time of your trial testimony?
No. And the records certainly reflect that I never spoke to Mr. Jackson after the trial in 2024. There was no conversations between us.
Well, let's go beyond Mr. Jackson. Let's go to any human being. Did you have any discussions with any human being as to whether the defense was going to compensate you for any work, travel, expenses, disbursements that you had or incurred up to and through your trial testimony?
No.
And at that time, were you still under contract with the United States Department of Justice?
Yes.
Now let's proceed.
A long day of testifying for Dr. Wolf.
December of 2024. Were there any conversations from the end of the trial until December of 2024, other than logistics? Well, was there any conversations of any kind? And please summarize briefly what they were, or texts.
The only communication that I had with the defense was Mr. Jackson. After I took the stand, I think that he sent me a text just thanking again for my time traveling up here. I said it was, it was great, and then we left, and that was it. I did not communicate with Mr. Jackson for the remainder of 2024.
Now let's go to recent communications. In 2025, did you have any communications with any member of the defense with regard to the potential? Well, let me go backwards. Let me go to the invoice. Let me go to the July invoice.
Okay.
How did you learn that that invoice was paid? If you learned at all, how did you learn that that invoice was paid?
I didn't learn. I didn't know that it was paid. I didn't even know it was sent.
Now let's go to this year. Did the defense approach ARCA to see if they might be able to testify in this trial that's currently pending?
Well, I think that the first communication of 2025 that happened between myself and Mr. Jackson was in February 13th of 2025. There was 2 calls, 25 minutes and 5 minutes, but it looks like just because there was a disconnect. So it was about a 30-minute call with him in February of this year.
And what was the substance of that call?
Well, I think back to that time frame, I became aware that I think that there was a motion or two regarding ARCA and potentially excluding our testimony for the upcoming trial. I also know that around that time, unfortunately, I ended up getting a significant amount of harassment through emails. And unfortunately, even spread into my personal life where my wife was affected. They were posting pictures of my 4 kids all over the internet. So it was somewhat of a difficult time on my end. And I think what prompted me to reach out to Mr. Jackson was to figure out what's going on. Why is my family all over the internet? Why are they talking about me? Why am I getting all these hate emails? So it was I think a conversation to figure out, hey, there's been several months that have passed. It looks like there's some motions pending against us. I'm getting a bunch of harassment. What's going on?
Do you have an understanding of why you were getting hate mails, hate emails, hate communications, your wife, your children? What did you conclude was the reason why you were receiving that?
I honestly don't know. I presume it was about comments made to me in court or that were represented about ARCA or myself.
So just so I'm clear on that, it was, you believe, regarding comments about ARCA and whether and what? Can you be a little more specific what your understanding was?
Well, I know that I received several emails that,
Threats.
insinuated that I perjured myself on the stand. Like I said, and a lot of hateful comments just about me and the work that I do. So I received several emails with respect to that.
Sir, do you believe you have ever made an untruthful statement at all with regard to this matter?
No, sir.
Have you done your best to try to provide accurate and truthful information in this matter?
Yes.
Now to the last part, which is, did the defense contact you with regard to potential further work? I want to separate out now and move on from the work that you did with regard to the U.S. Department of Justice, your February 2024 report. We went all the way through the trial in that matter. We went to the end of 2024. Now I want to come to 2025 in a different subject matter, which is communications with the
That is
defense
creepy, Sandy
about doing
Wendy.
further work for this trial.
Yes.
What was the nature of the communication? And so we can move through this rather quickly, but
Yep.
importantly, I want to get it complete and accurate. Just describe what the communications were on a timeline basis, subject matter, and with regard to your understanding of why you were contacted.
So subsequent to that February 13th call, as I mentioned, Mr. Jackson had indicated that he preferred to utilize Signal to communicate. So we exchanged a few messages and phone calls on that. Like I said, they were rather short.
I'm going to interrupt you for there a bit. Was there any discussion about the reason for Signal because the prosecution had been subpoenaing the phones of Mrs. and Dr. Reed, subpoenaing and seizing the phone of Miss Reed, that phones of defense attorneys had been requested to be looked at? Was there any understanding in your mind that there was a need to go to Signal to protect the defense and the integrity of the defense?
I didn't know that was happening, but like I said, I did not have a problem with communicating. To me, it was just another messaging app. I know people use all different types of applications, so I didn't have a problem with it.
Was there anything in your mind nefarious or underhanded about using Signal?
No.
And my understanding is it's the first time you used a Signal app with regard to a matter professionally. Is that correct?
Correct. Yes.
Did you get any understanding from communications with the defense that there was anything at all untoward about communicating through Signal?
No, I was not aware of any issue with using that communication.
Was there any communication whatsoever that you can recall on Signal that you have any concern about as you sit here today?
No.
And what were the majority of the communications, as best you recall, with the defense on Signal?
Well, as I described, I know that at that point, and like I said, it was primarily confined to a pretty short window in March, but Mr. Jackson had indicated that around that time, I think ARCO was being litigated by this court in terms of our involvement in the case. I know that they had started to, I think, receive discovery as it relates to the Commonwealth's accident reconstructionist and biomechanist. So they were, I think, interested in utilizing us potentially in the second trial. So I think that they had submitted a letter to the U.S. Attorney's Office to try to be able to work with us. I said that on my end, I could reach out to them because I hadn't heard from them in months. So I think it was around mid-March, I had reached out to the U.S. Attorney's Office to try to get my own clarification on whether or not we could move forward.
All right, so I want to stop you there. I apologize for interrupting you, sir. But what was the date that you reached out to the U.S. Department of Justice to see if you could participate in the second trial?
Probably around mid-March, maybe March 18th, March 15th.
Did you have an understanding at that time that the Commonwealth had retained an entirely new firm and expert in the area of accident reconstruction?
I think Mr. Jackson had indicated that there had been some material disclosed, but I think it was just a simple report or something of that nature at that point in time.
Was it a report, just like a page and a quarter or so of findings and conclusions and then a slide presentation? Is that what it was?
Yes, that sounds right.
Was any of that information at all helpful or meaningful to you in your ability to respond to that and to determine what was done and what ARCA might want to do in response?
Well, certainly not the report. The report was very, very brief. The PowerPoint, somewhat hard to follow, but again, it really didn't provide a complete picture.
And in terms of scans, electronic data, et cetera, do you recall when you finally got that information?
Well, I think that would have been after the defense officially retained us on March 26th. I think that's when we received that information.
So in terms of the information that you received, those scans, et cetera, did that allow you to proceed with any meaningful work?
Well, it gave us, again, a better insight into the foundation or the basis for the analysis, yes.
Could you have proceeded with a contract with anybody, not just the defense, but anybody, with the level of information you had before you got the scans and the data?
I think it would be very difficult to do so.
Could you have even created a scope of work based upon that report and that PowerPoint presentation?
Most likely not, just because some of the areas that Dr. Wrenchler and myself are particularly interested in are extremely vague in that report in PowerPoint.
Once you got the level of information that you have now, what is the ordinary time it would take in the regular course of ARCA's business to evaluate that information and prepare your own report, analysis, and finding? In the ordinary course, how much time would it take ARCA to do that?
Well, certainly for the nature of this case, as I mentioned, we were officially retained by the defense on March 26, 2025. As I mentioned, I myself just got word from the Department of Justice just a day or two, I think, prior to that we could move forward. So immediately, once Mr. Jackson, I indicated to him on the 26th that we did have authorization to move forward. He immediately asked that I send over, again, our typical procedure with the contract and retainer. And I think that same day, at the 26th or the 27th, his office sent over, I believe, links to notices of discovery, I believe 1 through 62, which I think encompassed about 800 gigabytes worth of information and data.
How much in relative term, 800 gigabytes? Is that a little data, medium amount of data, or a lot of data?
Voluminous, a lot of data. So
Or
we immediately
one
started to
Diddy
review
camera.
that. And again, I feel like maybe I speak for most experts. One thing we always want is more time, right?
Diddy's
So
in
in a
terabytes.
case like this, I mean, ideally we would be talking months to be able to sift through all of that information, be able to do analysis, be able to do
Or
testing,
3
be able
Diddy
to write
bytes.
a report, right? So I think certainly we are on the order of months, not weeks.
What did you do, however, if anything, to try to expedite the work and get it done as quickly as you could once you got the level of information you had from Aperture?
Certainly. So I certainly understood that the trial was imminent. So I worked as quickly as I could, along with Dr. Wrenchler, to review that material, and certainly in parallel try to determine, okay, what testing do we need to do to effectively evaluate and potentially come up with opinions for this case.
Did you put other work aside at ARCA to work on this matter?
Absolutely, work and personal things.
And personal things, what did you put aside? Just one example.
So the other week, my wife and I, we celebrated our 10-year anniversary. So
So it affected his personal life, I understand.
Okay, I'll move on, Your Honor.
Bev's such a sweetheart,
With
isn't she?
regard to the work,
What a shrew.
you performed it on an expedited basis, as you said. You shortened the time period down as much as your firm possibly could. Is that correct?
correct.
You said you would like to have had more time, correct?
Correct. But I understood Your Honor's order and I wanted to beat that deadline. So I worked as quickly as I could over the last week to ensure that, again, we could respect that deadline and we completed our testing.
And with regard to the testing now that you worked on that you just described, does that testing relate to any previous work, or is it all in response to the new expert for the Commonwealth, Aperture, and the new information from Aperture that came in iterations through the month of February?
It would be in response to Dr. Welcher's work. Certainly, much of what was alluded to in his report and PowerPoint was not discussed in the first trial.
Could you have done any of the work you've been working on the past month or so? Could you have done any of that work without receiving the Aperture report and slides and scans?
No, I don't even know what we would be responding to then.
So you needed the Aperture information before you could even start working, correct?
Correct.
Do you have in mind, or does ARCA have in mind, any further testing that you need to do, or have you completed what ARCA needs to do with regard to fairly and properly responded to the new work of Aperture?
I think we're satisfied and we've completed that testing, yes.
And what, if any, more work do you contemplate that needs to be done from, as you sit here today, going forward?
Well, as I mentioned, all the testing is done, so I think the analysis and the report to follow, yes.
To use expert engineering type terms, is it QA/QCing the report? Is it putting all the information together in a compilation so everybody can understand what you've done and make clear your findings and conclusions? Is that what's left to do?
Yes, and I will note, obviously, as the court is aware, we've produced all of that raw test data, photographs, video. So it's all there. The basis and the foundation for what the report will lay out has all been provided to the court.
You got ahead of me, and thankfully, so that my next question, which is, there's nothing that you have that you've done that hasn't already been produced to pursuant to the court's order. Is that correct?
No, I think that we've responded to the court's order, yes.
How long on an expedited basis? Well, let me ask it. In the ordinary course, how long would it take you to do this last part of your work in the ordinary course?
Probably, again, it can vary. Maybe around a month would be fair.
However, it would take a month in the ordinary course. How quickly can you get that work done fairly?
I'm hoping, if it pleases the court, hopefully May 7th will work.
And so you believe everything would be completed by May 7th?
Correct.
You are. That's all I have at this point, Your Honor.
All right, now you're going to get to see the prosecution, and no, out of earshot of the witnesses, this guy's an uber dick. They get to show off because they're not going to offend the
Doctor,
jury.
you're suggesting that it's going to take until May 7th for you to complete your reports in this case?
And the analysis, yes.
Do you know when this trial started?
I think like a week or so ago.
You provided raw data last Friday,
Yes.
but you would agree you still have not provided any reports.
Correct.
You said if you were notified or received information, you could have your testing and opinions done within a month, correct?
Potentially. Again, it would also depend on when we got authorization from the Department of Justice, which, as I mentioned, was at the very end of March.
I understand that. We're going to talk about that separately. I'm talking specifically about how long it would take if you received the information. You said that
You mean
could have
Haas
testing
law.
and reports done in 1 month, correct?
I don't know. I said the testing, the reports, and everything.
Would it take longer than a month?
Ideally, I think it depends on what kind of a report that we're talking about. I think if it's something along the lines that Dr. Wrenchler produced, I think it could be pretty quick.
You said March 26th is when you received authorization, and you're going to have things done by May 7th. So that's a month and a week?
Sounds about right.
Okay. Do you know when the Commonwealth in this case turned over Dr. Welch's information to the defense? Do you know?
I don't know, no.
Did you know that it was turned over in a report on January 30th?
Just the report?
Yes.
I didn't know that.
And
No.
the file in its entirety was
If he
turned
didn't
over
know,
by
then he doesn't
February
know the
5th?
date,
Did you know that?
idiot.
Do you know that?
I don't, Your Honor.
And if you had a month from February 5th to complete your testing and report, you could have been done by March 5th or even the second week of March, couldn't you?
Presuming we had authorization, the defense had authorization from the Department of Justice as well as ARCA, yes.
Putting aside the authorization, I'm going to ask you about that. But just the time you need to test, if you knew or received the information by February 5th,
He's likable, this
you
guy,
could
isn't
have
he?
been done by March 5th
Prosecutor?
or mid-March, couldn't you?
Potentially, yes.
Well, you're going to get it done that quickly now. So wouldn't that be an accurate guide to when you could have done it then?
It's certainly not ideal, but we certainly are working as quickly as we can.
I know it's not ideal, but isn't it the same time frame? Whatever it's going to take you from March 26th, you could have done from February 5th. True?
Again, I don't know the timeline in terms of what exactly was produced when from Dr. Wrenchler, so I'm not aware of that.
But I'm not asking about the timeline. I'm talking about the time needed to deal with this information. You said you could have done in around a month.
I think a month or more, yes.
So your contract with the federal government ended, ARCR's did, in June of 2024, didn't it?
I believe it was sometime last year,
Do
yes.
you know the Commonwealth notified the defense that they were going to have a new expert back in October of 2024?
No.
Are you aware of any effort by ARCR or the defense to try to facilitate an agreement that the defense could use ARCR as witnesses back in October or November of 2024?
No.
Are you aware of any efforts by the defense to try to notify the federal government to be able to use ARCR in December or January?
No.
And so as far as you knew, this came out of nowhere in March, that the defense wanted to use ARCR, or specifically you and Dr. Wrenchler, in late March of 2025.
No, I think, again, it was, like I said, around February of 2025. I know that, like I said, when I spoke to Mr. Jackson, that he had indicated that the ARCA issue was being litigated. And I think that, like I said, there was, I think, multiple motions pending against us, and he didn't even know if he could move forward with us at that point in time.
Do you know why the defense waited until February 2025 to even seek permission from the federal government to retain you and Dr. Wrenchler so you could review the materials?
Objection, Your Honor.
Do you know? Do you happen to know that?
I don't know, no.
Next question.
You shared with us communications
Bev's-
you had with
who-
the United States Attorney's Office. Were you receiving information in this case since the last trial from the defense or from the United States Attorney's Office?
What do you mean with respect to information?
Evidence, discovery, information.
From the Department of Justice?
Anybody?
No, not until recently, no.
So you haven't seen any discovery until after February of 2025. Isn't that fair to say?
Correct.
Now, when you were involved in this case before trial last year, we talked about your communications and conversations with the defense. Was anybody giving you information as an intermediary? Was anybody updating you on the defense of the case or giving other information to you?
Yeah, I think I previously testified that the Department of Justice was closely watching the trial and providing us information.
What information were they providing you about the trial?
I think that they provided information regarding the some of the witnesses that had testified with respect to, I think, the reconstructionists, and I think some of the evidence.
So when the Department of Justice was giving you information during the trial about witnesses, what witnesses do you remember they were giving you information about?
One that comes to mind was, and I don't even recall his name, it would have been the accident reconstructionist.
Is it a coincidence that when you were receiving information from the Department of Justice about particular witnesses testifying in this case, is it a coincidence that your phone calls and text messages are more frequent?
Is it a coincidence?
Yes.
I presume so.
Well, when you were receiving information from the Department of Justice about witness testimony in this case, was that part of the catalyst for you to either call or text the defense and ask questions?
No.
Did you ever share any of the information you received from the Department of Justice with the defense?
No.
When you were receiving information from the Department of Justice about witness testimony, that was before you testified, correct?
Correct.
And part of that, when they were giving you information, did they ever give you any live video?
No. It was
Yep.
just verbal
And
communication.
they were giving you updates and summaries of testimony?
I wouldn't say summaries. They just pointed out some key things I think that came out.
What were the key things they were talking about with the reconstructionist testimony? What were they telling you?
I think it was as it relates to the arm being outstretched, and I think some of the kinematics of the pedestrian. I also think there was some mention of potentially some DNA evidence.
And is that how at trial, even though you had no evidence that was produced as part of your report, or to consider for your report, that you knew that there was DNA evidence because of the intermediary?
Because of the Department of Justice?
Yes.
Yes.
Did you know there was a sequestration order in this case that you were not supposed to consider or review other witnesses' testimony or information? Did you know that?
I was never made aware of that. no.
Nobody made you aware about a sequestration order in this case?
No.
But you did, in fact, receive
That could be a problem.
about other witnesses' testimony before you testified in this case in front of the jury, didn't you?
From the Department of Justice, yes.
He worked for the Department of
What
Justice
were
investigating
you
this
advised
case.
about their
Duh.
testimony and issues in this case before your testimony in this case?
That's all I recall.
Well, you said it was more than one. You said some witnesses. Take a moment, think back. What other witnesses stand out that you were offered information from the Department of Justice about this case before you testified?
As I mentioned, I don't know which witness provided the DNA information, but I would presume that that's the other witness, yes.
So you heard information, you learned that there was information and testimony about DNA.
Yes,
And certainly when you took that information before you testified, you considered it when you testified, didn't you?
no, because again, our report was already solidified, so it didn't change my opinion in any way.
Well, not about whether it changed your opinion. You testified about DNA, didn't you?
I don't believe that I did, no.
I'm going to approach, if I may, Your Honor.
Okay.
This is your outline with your comments. You recognize this?
Yes.
I'd like to introduce that as an exhibit, please. Thank you.
Exhibit 3.
So as an expert, when you receive information, you need time to look at the raw data, don't you?
Potentially, yes.
You need time to look at the report of another expert, don't you?
Potentially.
And then you got to consider whether or not you think that their testing is accurate. You can test their testing, can't you?
You can, yes.
And you can also generate new tests based on what you've read if you think that there is some explanation needed. Yes?
Perhaps, yes.
And then you can write a report.
Yes.
So it's fair to say when an expert introduces new information, testing materials, it takes about, if not at least a month to process through that information, vet it, and then consider your own testing.
Well, if they've already authored a report and done their own testing, that should be solidified and memorialized already.
Well, if there's new testing, if a new expert does something new and an expert wants to look at it, you would agree to sift through that much information and consider and vet it and then do independent testing. It could take over a month, couldn't it?
If it's necessary.
And it would be the expert that determines whether or not that was necessary, wouldn't it?
Sure.
And if your report is not due until May 7th, is that what you said, May 7th?
Yes.
May 7th. It could take an expert, if they wanted to do testing based on new testing that you provided, over a month, couldn't it?
It depends. I can't answer that.
When you wrote that initial report and you provided the report, how many pages was it? 10, 12 pages?
The original DOJ report?
The report that you produced in this case with your opinions, yes.
That sounds about right.
Okay. You never gave the raw data for that report, did you?
No, it was all protected.
It was all what?
It was protected. It's classified.
Have you been asked for it? Has there been a request made for all the raw data that formed the basis of your opinions, of those initial opinions?
My understanding from communication with the Department of Justice is that all communication and work product is protected and cannot be disclosed.
So that raw data that's necessary to you for your evaluation and testing, that wasn't provided in this case, was it?
For the first trial?
Yes.
No.
And videos of the demonstrate, you built like a potato cannon, right?
I'm sorry, what?
Potato cannon.
If that's how you want to characterize it, sure.
Okay. Did you take videos of it when you were doing your demonstrations and tests?
Yes.
Never turned over those videos, did you?
Again, we're talking about trial one. As I mentioned, for trial two, let me
I'm asking about
finish.
trial one, so
Okay.
no, I want you to focus on.
Okay, no,
No, don't tell us the truth,
Never turned over
right?
any
Just
of
take a.
that- those videos, did you?
again, we were not able to.
And was there any failed testing the first time around?
No.
In addition to videos, I'm sure you had other raw data, notes, photographs, right?
Yes.
And so when you look at a report, so for example, you saw Dr. Welch's report and you had access now to his file and data, correct?
Correct.
You reviewed that, didn't you?
Yes.
Because to be fair, you need to review not just the report, that's just someone's opinion. You need to review the raw data, don't you, to get an accurate understanding of an opinion?
Right, which we have already provided
Right,
in
so-
response to Dr. Welcher.
Without video and without the raw data, as an expert, there's no ability to really vet the reliability of your first experiments that led to your testimony in trial one, is there?
I think you might be confused. Again, our role for this round.
I don't think
for-
I am.
Objection, Your Honor, you should be allowed to answer.
I don't think I'm confused. I'm talking about trial one.
Right.
You had a 12-page report. You provided no video, no raw data, no notes, correct?
Correct. But for this trial, sir, we are being asked to respond to Dr. Welcher.
That's
Okay.
not what I'm
We
asking
have
you.
provided everything that he would need to evaluate the testing that we have done.
That's not what I'm asking. What if he wants to evaluate the testing you did the first time? Are you going to come into court? Do you hope to testify about the opinions you gave the first time? About those 4 opinions?
I don't know what the defense's plan is for us. My understanding is that it's to evaluate and respond to Dr. Welcher.
All right, with that, I need to see counsel at 10.
Yeah, because Bev ain't going to allow any of this to get in. She's not happy. All right, people. So no jury in the place, right? And when there's no jury in the place, the prosecution and the defense don't have to be on their best behavior in any way, shape, or form. You'll notice these guys are putting on a good show and the voice goes really high and you've got to be kidding, right? It's all incredulous. If you did this shit in front of the jury, they would hate you. And that might taint exactly, how it goes. You really got to walk a fine line between getting what you want out of somebody and trampling all over somebody and looking like a jackass. If you do that, you can make the jury hate you and they'll end up convicting your client because you're a dickhead. So outside of the jury is where these guys get to hurl insults back and forth at each other and really try to, they don't have to be kind. They can be dicks. And I would imagine that most of the time they want to be, right? Now they have an opportunity. This is a voir dire of sorts because they're trying to determine whether or not this guy is tainted. Now, it's a beautiful example of how getting this much of a truth will give you a completely different answer. If I ask the guy and I say to him, you didn't turn over any of the evidence that you were supposed to, yes or no? Or you didn't turn over any of the evidence, from the first case. No, I didn't. But no, I'm not letting that but in. The but is the first thing that he did was work for the Department of Justice. And everything that he did in terms of his work with the Department of Justice is sealed. It's sealed because it's an investigation of cops that were dirty, right? Dirty cops. That's the reason that entire puppy is sealed, is because of Trooper Proctor and all the stuff he did. And it got Trooper Proctor fired on this case. But the prosecution doesn't give a snot. They're just trying to get the little answers. They don't want the truth because the truth is, I can't hand that to you. The Department of Justice would screw me over if I did.
And let's bring Dr. Wrenchler in here, please.
Thank you, Your Honor.
Okay.
By the way, Dr. Wrenchler is the clown. I'm sorry. He's the other constructionist. He believes that a car beat the hell out of somebody. Sorry. Even the coroner would not sign off on this being a death by a vehicle. Doesn't stop Auntie Bev. If she goes with the truth, then all of those cops, right? That means that they let somebody get away with murder. Because if Karen Reed is found not guilty, then the person that killed her boyfriend is not going to ever see any justice. If the cops did this, John O'Keefe's murderer is never going to be caught.
All right.
Auntie
Dr.
Bev,
Wrenchler,
you're
this
a
is going to be
queen.
very quick. Go ahead, Mr. Brennan. We
Thank
just
you.
need his name.
Good afternoon, doctor.
Good afternoon.
Could you please state your name for the record and spell it?
Dr. Andrew John Wrenchler, ANDREWJOHNRENTSCHLER.
You've testified before in this case
I have, yes, sir.
at a last voir dire in a past trial.
That's correct.
Did you have conversations and communications with the defense before your last testimony?
I did, yes.
Did you use text messages to communicate?
I believe there was maybe one text message.
How about phone calls?
There was maybe 1 or 2 phone calls, I believe.
Okay. Would it be fair to say there was 6 text messages for you?
Yeah, I believe I sent one and then there were 5 sent to me.
And were there 23 phone calls?
No, I don't believe so.
Have you looked at the records outlining the phone calls that supposedly you made to the defense?
I looked at the records from the defense, but then I looked at my own records, which indicate a different number, only 3 phone calls, I believe.
Okay, so the 23 phone calls that are summarized, you don't think you made those phone calls?
No, if you look at them, it's like 1 minute, 2 minute, 3 minute. And in that time period, according to my phone records, I have like a 21-minute phone call that encompasses most of that time.
Did you discuss with the defense before your testimony anything about this case?
I don't believe so, no.
When you say you don't believe so, do you
Bless
remember
you.
speaking to them about this case at all?
I remember speaking about my qualifications and my background, and I believe that's it.
Did you ever use any other medium to have conversations with the defense other than text or emails or phone calls?
No, sir.
Did you ever communicate with them on Signal?
No, sir.
Why not?
There was no reason to.
As an expert, when you communicate with clients, there's no concern about having it in writing, is there?
Well, no, crooked
I'm sorry,
cops.
Keeping a
repeat?
record, whether it's a phone call or a text message or an email, there's no concerns when you're dealing with clients having a record of that, is there?
I don't believe that ARC has any specific policy for that. No, sir.
Did you keep track of your hours prior to your testimony?
I did, yes.
And before you testified, did you have conversations with people from the Department of Justice about this case?
Yes, I did.
Did they inform you about witness testimony?
They did inform me, yes, about testimony and situations and events that came forth in the trial that I was not aware of.
Who decided whether it was going to be an issue worthy of talking about before trial?
With the DOJ, you mean?
Yeah.
Well, that certainly that would have been up to the DOJ. I mean, I would have had conversations with them. I don't believe that I asked or requested anything, but they were
Sure.
called to update us about what was going on.
Do you know why?
Now
they
you
were
know why they
calling and
picked
raising
the other
issues
guy
with you?
to put on the
I do
stand.
not know, no, sir.
And by calling and raising issues and telling you information, even if you weren't requesting it, it helped prepare you for your trial testimony, didn't it?
They had a choice
It would
between
certainly
this
help
guy and
prepare me
Dr.
to
Wolf.
understand what was going on during the trial, yes.
Did you know there was a sequestration order? That there was supposed to be no discussion of testimony and issues that were occurring in the courtroom before you testified?
I'm going to allow it. Were you aware of that, sir?
No, I was not.
Of course she's going to allow
After
it.
you testified, before you testified, did you get a chance to meet anybody from the defense?
Just when I came to court, I think for the voir dire is the first time I met anybody.
Did you just spend time with the defendant and the defense after your testimony?
Well, after my testimony at trial on the 24th, yes, I was provided a ride back to the airport, and I believe I was the last witness. So before my ride to the airport, they said, there's a lunch next door. We need to get somebody else to take to the airport. Come over, have lunch. I had lunch, stood in the corner, and then got a ride back to the airport.
Spend time with the defendant and her family?
Oh, they were certainly there.
Did you talk to them?
Well, they talked to me. As I said, I ate my lunch, and then I actually went and stood in the corner, and then I believe some people came over to talk to me and approach me.
So you spent some time with them?
Certainly, yes.
Okay. And sir, I understand the report is not going to be ready until May 7th or after?
I believe currently that's what the estimated deadline is, yes.
And so in evaluating Dr. Welch's materials, you wanted to look at the raw data, the conclusions, the findings, the PowerPoint, all the materials, right?
Yes, you'd like to review all the materials before coming up with an
So then you
opinion.
make a decision on what you think is appropriate to contest or maybe agree with, and then do your own test if necessary, correct?
To be able to respond to what those opinions and allegations are, yes, sir.
And it's taken you at least a month to fairly do that, hasn't it?
Well, I believe that's what we've had, a month. I don't know if it's taken us a month. That's basically all we've had up to this point to do that.
And it's still not done.
No, not yet. That's correct, sir.
All right. Is that it, Mr. Brennan?
That's it, thank you.
All right. Can you get that report and everything completed before the 7th? If I order you to do so?
If you order me to do so, I mean, I could certainly try and expedite it.
All right. I appreciate that. Thank you very much. You're all set, sir.
Thank you, Your Honor.
All right.
I like how Bev just shut it off.
For 1 minute.
Interesting. Really, really interesting. Is it my imagination, or does absolutely every single time that that Bev has an opportunity to rule for the prosecution, she does, and every time she has an opportunity to rule against them, she does not. It's absolutely maddening, the patience involved with what it must
That's
take
it.
to
Thank
not
you.
go nuts.
All rise for the court, please.
Oh, it's a wrap?
Goodbye.
Let's see if it really is. Goodbye. All right, so let's wrap this up real quick. If you were trying to put that together, the ARCA, the company that had been hired by the Department of Justice to look into, they didn't get hired to look into this, to see whether or not there was an accident I mean, or whether or not they thought that this may be literally the cops killed this person and they were going to be somehow able to prove that. But once again, all based on what happened outside. But when the defense had an opportunity to look at the work that was done by ARCA, and they did this prior to the end by writing to them and saying, hey, can we get a look at what you guys have done? Prosecution could have done the same thing. At the first time they had a voir dire, in other words, before you bring somebody on and you say this person's a witness, you could say, Your Honor, I don't know that this person's a witness, right? I mean, an expert, this person could be a jackass. For all I know, there's somebody you grabbed off the street who's going to say that they knew this person for whatever number of years. They have a voir dire process where both the prosecution and the defense will ask questions of this witness to determine whether or not they're bona fides, right? Do they have an education that proves that they're an expert? And very often the prosecution gets up and they'll ask questions, or if it's a defense witness, they'll get up and ask questions all about the person's great education, how many awards they've won, how many times they have worked on cases like this, yada, yada, yada. The other side will get up and try to paint the person as a jackass, right? And dig dirt up on them or anything else so that they can impeach them as a expert. Both of the people that you just saw, Wolf and the gentleman that went after him, Wrenchler, both of those guys worked for ARCA, and both of them worked on the Department of Justice case against Trooper Proctor, the one that got Proctor fired. Former Trooper Proctor. He actually got fired. That investigation, the defense had an opportunity to work with one of those two guys. There wasn't a real point in putting two of them on the stand. As Dr. Wolf had said earlier, it would have been duplicitous. They would have been talking about the same thing. He would have been giving similar testimony. They both do the same kind of reconstruction. There's no point. They also said they basically worked on it on a 50-50 split. So the defense chose the guy with the personality. Keep it real. Dr. Wolf on the stand sounds like he's confident. He knows what he's talking about. Wrenchler, not so much. He sounds a little bit more like, well, like he's probably really good at what he does, but he's a little bit computer nerdy. And I'm not busting on anybody, but that's kind of how he comes across. Dr. Wolf looks like he could be an actor, right? He's a handsome bastard. He looks like a bit of an alpha male, and he sits on the stand and sort of his answers are very to the point. I thought it was fascinating that he talked about almost bailing on this case because of all of the hate. And if you know the story more, you have no idea how much hate, like death threats and the whole works. And it's amazing because the people doing those death threats think they're doing the Lord's work. You see, the Karen Reed case, like so many other things in this country, has become so polarizing that the people that think Karen Reed killed John O'Keefe are vicious. And the people that think she didn't are vicious. Not picking on anybody in this, but there's been a lot of crap on both sides, right? The Karen Reed people like to pick it out in front of the courthouse, which I understand. I think she got railroaded. But if what you're doing is somehow going to jeopardize what's going on inside the courtroom, then it's not in her best interest in any way. And some really, there's some questionable stuff that's been done on both sides of this, because anytime it's an us versus them thing, anytime it's we're these guys and they're those guys or those gals or whatever, hell, I don't have to tell you this freaking story. You've been watching it. Huh? It's pretty sad to see it happen at a level this important. Say whatever you will about this case. Karen Reed's life is on the line, right? This woman's life is on the line. And we are fighting, we being the side of good versus evil, in my humble opinion. We're fighting a machine, right? A machine that already knows Karen Reed has been found not guilty on charge 1 and charge 3, but they're going to try her happy butt for it again. Double jeopardy. Textbook, double jeopardy. The jury found her not guilty on 1 and 3. Now they're trying her again on it because Bev's crooked. Not allegedly. There's no way to look at this objectively and not go, wow, they got dirt on this woman. They got dirt on Auntie Bev. She signed some jacked up warrants, maybe. Maybe she, who knows? But to look at this from a distance, this is just really suspect stuff, in my opinion. You know, what it came down to is they didn't have the right jury form. So when they came back and said we're deadlocked, if they had given them the correct jury form, what makes you believe that they didn't give them that jury for the wrong one on purpose? Right? Why wouldn't they? think about all of the coincidences that we need to believe for this thing to be real. We need to believe that in the Sally Port, right, at the police station where they brought Karen's car, right, Camden PD, that camera just magically inverted itself. The timestamp magically inverted itself, and the timestamp magically is missing a chunk of time. Just happened. We don't know. The second camera, the one that would have showed the correct side of the car, the one that Trooper Proctor was over there working on the tail light of, well, that one's not working. Another coincidence, right? Or the library, which should have showed that part of the car. Did it? No, because that section of film is missing. These are coincidences. Yeah. Here's what we do know. We do know that we saw Karen Reed's car strike her boyfriend's, right? His truck, as she was backing out. And she struck it on the side that has a broken taillight. Wouldn't have been his head that did it. My bet's on the fact that it was the car. And she hit his truck enough to make the tires move. We saw that on video in the first trial. Yeah? Okay. So when you start to put it all together, it starts painting a completely different picture. First time around, people said she got to the scene and said, logically, like anyone who was shaffazed the night before, oh my God, I might have killed him. Do you think I killed him? I could have killed him. Do you think I killed him? Please tell me I didn't kill him. Not, I hit him. Right? Could I hit him? Could I have hit him? First time around, nobody said anything. Second time around, there's a whole new story. First time around, he wasn't covered in a blanket of snow. Second time around, there's a blanket of snow on him. That's why nobody saw him. If you know anything about laying in the snow, your body would have to get real, real cold before the snow would start to pile up on you. At 98 degrees, the snowflakes that hit you, they're going to go and melt real, real quick. And when you go, well, hypothermia. Number one, the forensic pathologist said there is no hypothermia, right? The new expert they're calling this time has said absolutely no hypothermia whatsoever had started. But even if it had, you know what hypothermia is? Your body, hypo, right? Below. Your body goes below 98.6 or 98.8 or whatever they're calling it now. Okay. So if your body temperature was at 92, you're hypothermia. Snow ain't going to pile up on you. You're 92 degrees. The snowflakes that are coming in are 40, right? 39, 38, 33, depending on the temperature. No, nothing's piling up on top of you. That's sheer bupkis. Now, if you had a thick coat on, the snow could pile on that coat because the coat, like a down jacket, right, would act as an insulating layer between your body heat and the outdoors. And that snow could have piled up over the top of John O'Keefe, but he wasn't wearing that. The guy was dressed like it was June, in spite of the fact that the first paramedic in the first trial was 100% sure that he was wearing boots, right, and a puffy jacket. He wasn't. No, he's wearing a t-shirt, right, or a sweatshirt. He had nothing on. He was dressed in really inappropriate for the weather. But as far as smell testing goes, how about this one? You Karen Reed. You drive your boyfriend to a house for an after party where he wants to stop by and see if the party's going on. What are the odds he doesn't go in? Honestly, what are the friggin' odds? He's a cop who's been hanging out with other cops, power drinking. They shut the bar down, so they're heading back to the after party. He's going to get there, not go inside and hang out on the lawn for all that time while she's texting and calling and all of that. Doesn't seem to make a lot of sense, does it? Honestly, does that pass the smell test? No. He's going to go running inside. And probably, right, if everything went well, he's going to run inside and go, hey, what are you guys doing? He's going to run downstairs and say, you guys partying? Karen's here. She likes drinking scotch. You guys got scotch? Because there was some talk about what certain people drink, whatever. But he went in for a question. He went in to see if the party was happening. And he never came back out. There's no other explanation that makes any sense. Oh, they were fighting the whole time out front, right? They were fighting, got in this huge argument. And then she gets the car going fast enough to do that to him and not leave any other mark, any other place on his body. Where are the the tire tracks, right? And crap all over the lawn that should be torn up. I'm confused by so much of this. Doesn't make any sense to me. Or what, she tagged him on the road and he flew massively and landed next to the magic flagpole that somehow was always within 30 feet of the...
Giant cleaning on that house.
Oh, yeah. Well, they sold the house, right? They sold this house. This is your ancestral home. and you dump it right after this all goes down, get rid of the dog, all of this looks bad. Doesn't mean anything, right? I mean, not factually, but it looks real bad, doesn't it? It also looks really bad that when they first got there, there was no glass whatsoever anywhere on the lawn. Magically, after Karen's car gets down there and Proctor hangs out in the corner on film, even though it was flipped around, we know what he's doing. We know he's on that side by that corner. And then poof, there's glass and plastic everywhere. They found 60 pieces or 48 pieces or some shit. Bunches of it's everywhere. That doesn't smell right. There's no chain of custody for any evidence in this case. Chain of custody is a process by which you make sure you can document where the frickin' evidence was from the time you picked it up to the time it shows up in court. So if it goes down to be tested, somebody signs off for it. When it goes with FedEx, even that kind of crap, every single step along the way has to be signed off on because somebody could tamper with the evidence. Trooper Proctor said stuff like, well, it was in that office down at Camden PD. Oh, it was in an office at Camden PD where you guys were supposed to recuse yourself from doing anything because there were so many freaking conflicts of interest with the entire crowd. And Proctor said, oh, no, we just weren't supposed to do interviews there. Does that pass the smell test? Huh? Like Brian, so tired and drunk, he wanted to go home. He didn't want to party anymore, but he didn't go home. He went to Camden Police Department and started parking cars, driving cars around in a snowstorm and waiting for that phone call. Remember that 20-second phone call? People, this stinks to high hell. Well, yeah. How about butt dials where I butt dial you, you butt dial pick up, I butt dial you back? Come on, people. First of all, butt dials are a thing of the past, aren't they? It's a lot harder to butt dial than it used to be. It really is. You know? Common sense case. Yeah, this doesn't make any sense. That don't make no sense. I mean, if you look at this logically, is it more logical that this guy whose both eyes are swollen shut, he's got a contusion to the back of his head, a shot to the back of the head that did him in. All of this happened from her backing into him. And from here down, he looks like he's been dry cleaned, except for one arm, which has furrows. You remember that? The gentleman that worked on it said there were furrows, right, cut into the arm. What did that on the lawn? Seriously, what did that on the lawn? Because the car had to have hit just his face. I'm not being a wise ass, by the way. That car had to have hit his grill and nothing else because there's not a mark anywhere else on his body. You know what? When stuff like that happens, when you get into fist fights, for real, you get into a fist fight where people are throwing haymakers at your face, you end up with a really jacked up face and the rest of your body looks fine. Unless, of course, where you're fighting has a large German Shepherd, which by all accounts had a bit of an attitude problem anyway. And then that dog did what that dog was supposed to do, in my humble opinion, right? If you're having a fight in your house and you have your own dog, the dog is probably going to attack the person who's fighting with you. That's logical. And it tore through the shirt and he had big cuts on his arm. Now, they said there was no, they did all this testing on the arm. And the only thing they did find was pork. Odd, right? They didn't find any dog DNA or anything like that, but they found pork in the guy's arm. Now, there are people who suggest that because dogs eat so many chew treats that are made of things like pig ear and things like that, that what happened was something from a chew ended up in this cat's arm, right? That's what happened to John O'Keefe's arm when he got bit by the dog in theory. Now, there's no proof to that. But what in that car wreck did that to him? Because when he hit the ground, it didn't do anything to the rest of his body. When he hit the ground after getting pummeled by a car, the only thing damaged is his head. And then, of course, the arm, which looks like a dog bite. Where's the rest of his body? If that were going to happen to his arm, you would assume that maybe other parts of his body might have taken a shot. But the arm magically was out there. This is like the Kennedy bullet, for real. The car magically just digs a bunch of holes into his arm, blacks both eyes, jacks his nose and the back of his head, right? Busts his lip. Logical. Yeah, that passed the smell test. Let's hear what the coroner has to say. The coroner says, hey, no way I'm signing off on that. Not making that up. The coroner said that's not a vehicular death. Any other place in the world you might go, well, then maybe we shouldn't prosecute this. If the coroner, whose job it is to determine the way somebody died, says this isn't a murder, it seems to me that we need to take a good hard look at why a judge would go, nah, I'm going to let this go forward anyway. Right? When you look at all of the totality of all of the things that just scream, hey man, there's some reasonable doubt here. Why does she let this go forward? To protect the people whose house that is, right? To protect two very prominent families in this town who together, allegedly, according to the defense, their theory is that a bunch of drunk cops off duty beat a guy to death in the house. And we're going to hear apparently about a lot of different kinds of DNA on the shoe. We're going to hear about a lot of things. And Jackson, who as we've been watching, this guy's been pretty spot on. He's really done a very good job, especially swimming upstream. Because you got Auntie Bev doing everything within her power to make sure nothing gets in. So for Jackson to do the bang-up job he's doing is honestly shocking. But he said in his opening statement this time, we're going to prove a couple of things. And one of them is he went in that house. I don't know what's going to come up. I don't know what the evidence is that they're going to pull out. But he said, make no mistake, we're going to prove he went in that house. If they can prove he went in that house, that means everybody lied. You got to start asking yourself, why do people lie? And don't get it messed up. People lie for a billion reasons. They do. They lie to get people to shut up sometimes. Trust me on this. Say whatever the hell you got to get someone to shut up. People tell lies for stupid reasons, and they tell lies for a myriad of reasons. And you know what? Every single time, they jump up and bite you right on your backside. But this is one of those situations where if they can put John O'Keefe inside that house, then what do we got? 13 people that have lied? Maybe more? I hope that we get some form of justice for John O'Keefe, right? It gets really easy to talk about cover-ups and proctas and all. This is something that we can get lost in the weeds. But when they show what kind of looks like a jury box, but it isn't, and you see a bald gentleman sitting there, and very often John O'Keefe's mom is next to him. That's a cop family. That's a cop family. It's got to be a hell of a position to be in if you're their family, because that thick blue line thing is real, right? And they got to feel, some allegiance, and they want to blame Karen, because if they don't, it means cops killed their son and didn't care enough to say anything about it. They beat him and probably just let him lay there and die. The medical examiner, I don't think, is going to say that the shot killed him instantly. The shot to the back of his head just turned off his computer. He wasn't getting up. He wasn't walking around, and he wasn't communicating. Doesn't mean he was dead. They let him die. If the defense theory is correct, they let him die. Probably inside because, again, no hypothermia. But at some point, they carried him outside, put him on the front lawn, and then walked back inside, shut the door, and pretended nobody was friggin' home. And I'm not making that up, am I? Look, the people show up. There's lights everywhere. There's a woman outside screaming at the top of her lungs, pulling her shirt up so she can lay on top of this guy to try to bring up his body temperature. And she's doing CPR on him. And apparently, he's leaking bad out of his grill from the ass kicking he took the night before. So she's got blood all over her. This is a pretty rugged scene. And according to testimony, they looked out and thought, well, if we go out, we're probably just going to make this more difficult or whatever, right? They were going to leave it in the hands of the professionals. Are you woofing me? This is a cop that you guys are supposed to know. You're not going outside to help him? Give me a 2 if you think that sounds like BS. All of those people in that house are trained first responders, right? These are trained first responders. You're going to let somebody who, I don't know, maybe she's great at CPR. Didn't sound like it from the 911 call, did it? But you're going to let that go down. You're not going to go outside because you know what a pain in the ass it is when somebody tries to come out and get in the middle of your crime scene, right? I'm sorry, people. If that passes the smell test with you, there's something wrong. You're not paying much attention. It just doesn't smell right. Doesn't smell right at all. Feel me? So tomorrow we're going to rev back up, right? And it sounded a little bit like Bev is going to allow this to go forward. And I think she has to. The only part that I heard the prosecution make, if by some chance that sequester order, it's very confusing, this whole issue today, because you had a Department of Justice, right? That's the FBI and the federal prosecutors that were taking a look at this case, and they hired ARCA. Now that's over and closed, and the defense hires ARCA. Now they have the knowledge from the first case. How do you not bring knowledge with you, right? How do you leave what's in your head behind? Well, obviously you don't, right? So this is a gray area. And whenever there's a gray area, Bev is going to take the wrong tact, I promise. If, however, she throws ARCA out of this, the world is going to, this to me seems very glaring. If she doesn't allow these people to work with the defense, I think that this is going to be ugly. No matter how you look at it, folks, reasonable doubt, right? There's so much reasonable doubt. I don't think you'd have to be an attorney. If you could sit down and look at 12 people in the jury and say, you guys have watched Cops, right? You guys have watched Cops. 2 cops show up, and there's a guy laying on the front yard with a broken glass next to him, right? His eyes are blacked in. He's got blood coming out of his mouth. His nose looks messed up. He's got a mark on the back of his head and what looks like some dog bites on his freaking arm. And he's laying in the snow, apparently deceased. Question: do you go inside? There's your case. All those cops show up, right? Cops freaking everywhere. None of them said, maybe we ought to go inside. Huh? They didn't need to, you see, because the cops came out and went, oh, no, he never came in last night. We were at a bar with him, but he never showed up. Oh, case closed. Karen killed him. There's your reasonable doubt. Seriously, are you kidding? There's your reasonable doubt. If that doesn't work, let's look at the rest of the police investigation. No such thing as chain of custody on any of the evidence. None. In fact, if you remember the first trial, they pick up a bag and they say, what's in this evidence bag? And they just write on the outside, right? There's not evidence things stapled to it or whatever, but sweatshirt, whatever. Turns out that the bags were wrong, right? So no big deal, right? Who cares? What's the big deal? This sweatshirt was supposed to be in that, and there's something else in here that the big deal is who switched it. Maybe it was mismarked, but this is why you have a chain of custody, because maybe somebody took it out and messed with it. Maybe someone took it out to get a little bit of DNA and maybe put it on Karen's car. For real. These aren't stretches. You understand? These aren't stupid concepts. There's a reason you have chain of custody. Explain this to the 12. That might do it. And then start talking about flipping around camera angles, about counters that stop for a couple of minutes, about videotapes that disappear for a couple of minutes out of the library. Come on. All of these things happen. These are all coincidences, right? It's a coincidence that Haas longed to die. It's a coincidence that it looks like it was Googled at 2:00 in the morning, right? It's just a coincidence. The technology, it is what it is, but she just opened a tab then, right? She was looking at porn. I'm kidding. But she was looking at whatever, right? It's raining men. Hallelujah. I'm not being funny. I think that's what one of the things she looked up was probably the Weather Girls, because she said Raining Men. That is a song, I believe, is it the Weather Girls? No, it's something like that, though. Maybe I'm wrong. Anyway, Raining Men was the last thing that she looked up. And then the next morning when she got up, she Googled Haas longed to die in the cold. Again, I think that's logical. But it doesn't look good, right? When the timestamp says 2:47 or 2:27, you're Googling Haas longed to die in the cold. I'm sorry to say it, but if you can bring in an expert that says she actually did that then, I would say that's reasonable doubt. I think on 1 and 3, it's a joke, right? 1 and 3, easy as hell. That second one, Okay, do you believe that he got hit by a vehicle? If you believe he got hit by a vehicle, well then Karen, Karen Reed's probably your girl. But the coroner didn't believe that. And with all due respect to the 12 of you sitting in this box and the prosecutor and Auntie freaking Bev, there's only one person here that went to school for half of their friggin' life to figure out how people die. That person doesn't think this person was killed by an automobile. Neither does anybody else that's looked at it, except for these hand-picked specialists that, I'm sorry, I think these people can be bought, right? You got enough money, you can get a witness to go on there and say whatever and get beat up on the stand and get torn apart. Who cares? What do you get, $25,000 or whatever to go in and testify? Who knows what they're getting paid? But there are experts who get, you wouldn't believe how much money, right? Experts don't show up and do this for free. They get hired, right? These people get paid. But I don't know. That to me, and I'm no lawyer, people. I'm a dumb convict, right? And a con man. But it seems to me that that's plenty of reasonable doubt to sprinkle all over this case. Is it me? It was the weatherman? How about that? The weather girls. Hallelujah, it's raining in. Well, we know what Jennifer McCabe was thinking about. She just may be a fan of the song. I think they may have been doing karaoke. Weren't they talking about doing karaoke at an earlier deal? Who knows? They get thousands per hour plus expenses, says Sandy Wendy. Yeah, they make really good money. And I know in some really Barry Scheck, right? He was an attorney that was part of the Dream Team, but he was first brought on. This is the OJ thing. He was first brought on to be a DNA expert, right? Like he was just going to be, brought on. Some of these people make an absolute fortune. Especially people for the defense, because if you're Sean Diddy Combs, the person that they're going to hire to help pick a jury to do the voir dire process, those people could charge $1 million, $2 million a shot. Better pick a damn good jury for that. Actually, doesn't much matter. It's one of the greatest jobs in the world, right? I mean, even if you fail, it's not like the people come back and go, "Can I get that cash back?" The diddler got 60 years. He didn't pick a very good jury. By the way, he did turn down that deal. He is moving on forward. And the word is, it's not looking good for the diddler. As I said, I'll be probably covering that tonight on the lifeboat. We're going to go into that a little bit deeper. But allegedly, there really is a video of Cassie Ventura inside the Intercontinental Hotel. Not the one that we all saw, right? She has clothing on for that, so we can see it. The other one was a beatdown that took place inside, allegedly, when the freak off was going on. She, for whatever reason, was no longer having fun. She would have been happy to have it stop. It didn't. So there you go. And that's kind of it's kind of where we're at, folks. And it's kind of where we're at. So I will be back tonight. I am hoping all of you come back. And I'm sorry that we missed the beginning of the Dr. Wolf thing. I actually bought into it when Auntie Bev said that she was that was recessing for the day. She was recessing the jury for the day, which is why we were doing the voir dire process based on Dr. Wolf and his partner to see whether or not they were going to allow this in based on a conflict of interest, right? The conflict of interest having something to do with the fact that these guys were working for the Department of Justice to help get Proctor fired, right? And they did a hell of a job, didn't they? Can you see why the prosecution does not want these people working for the defense? Because they already successfully went in and said, this was handled so poorly that the person that headed up your investigation needs to be fired. How does that sum it up? Did the police do a good job? No. They did such a bad job that the guy needs to be fired. Reasonable doubt? Huh? Reasonable doubt? The Department of Justice, they didn't press charges, but how close do you think they came to? You talk about a dereliction. The very first night, he's on chat talking about the woman's rack in her butt. He's a class act, that guy. I should hang out with him. He'd make me look fantastic. Between now, folks, and the next time that I see you, I want you to do me a favor and practice a little harm reduction, huh? In everything that we do. Let's be nicer to one another. Harm reduction. It's a fairly simple concept, honestly. So I will see you all tonight, 7:05. That's on the West Coast. All right. Be good and God bless.